Nice battle, case number 25C-1245.
Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Ms. Battle, please hit *6. Unmute your device and state.
Hello? Hello?
Please state.
It's Denise Battle on a special appearance for the record to contest the jurisdiction and the facts before this court.
Yep. All right. Well, Ms. Battle, I'll tell you that this matter is appropriately in the correct court. The court does have jurisdiction.
And it's based on what? What is on the record that is based on that the court has jurisdiction?
The fact that this is a case that is within the jurisdiction of the Township of Ypsilanti, and if you have issues related to any contracts, that would be within this jurisdiction as well. So all of that is within the jurisdiction of this court.
So you're saying that the contract is in jurisdiction of the court?
That is what I just said, ma'am.
All right, and the contract has been rescinded. So how is the contract in the jurisdiction of the court if it's invalid?
Well, gets to rescind a contract on their own. That's
what are you talking about? I have the right to rescind a contract by right of common law.
Ms. Battle,
that doesn't involve court.
Ma'am, you need to stop talking or you're going to get held in contempt of court. Mr. Fantier, have you had a chance to talk to Ms. Battle? Talk to Ms.
You're breaking up. I can't hear you.
Mr. Fantera, do you need to speak with her, or are we ready to...
If you want me to speak to her, I'll speak to her. You know, I mean, she talks about rescinding the contract. Does that mean she's moving out?
I'm sorry, you're breaking up.
Are you moving out?
Are you moving out?
No. Why would I have to move out?
Because if you rescind a contract, you okay, fine. Your Honor, I think we just let's set this for trial.
Okay. One moment.
This case has also been in the it's in the circuit court. A petition filed for an injunction. I did serve you all. It is set on the 30th.
Yes, ma'am. I heard.
We're aware.
Okay. And once again, I do not submit to the jurisdiction of the court. The contract is rescinded.
So how can the contract?
And I am not a legal person.
You're not a legal person?
How can a contract? No, I'm not a legal person. I'm not a legal entity. No, I am not. And you have to prove that on the record.
Actually, I don't.
I'm sorry.
Can I ask Ms. Battle a question, Your Honor, real quick?
Sure.
So, Ms. Battle, so you can live there forever without paying rent because you're not a legal person?
That's not what I'm saying, but the contract itself is invalid. I'm saying that you don't have any personal or subject matter jurisdiction over me. Over an invalid contract, no. And over me not having the legal capacity to be sued, yes. So if that's how you want to take it, then that's how you have to take it. But that's what's lawful, and that's what's written in the law.
Let me just tell you, I think you're wrong on both counts. I would expect that we would.
It's okay for you to think that I'm wrong, but the facts still align with what I'm saying.
Okay, Your Honor, I think we should have a trial.
All right, before we get into the chaos, let me warn you right now, this is not just one sovereign citizen meltdown. This video is a sampler platter of bad legal ideas, misplaced confidence, and people who believe the law stops working if they say the right words in the right order. 4 different defendants. 4 different courtrooms. And not a single functioning legal argument between them. That we're starting with an eviction case that should be straightforward, but isn't, because the tenant claims she's not a legal person, the contract doesn't exist, and therefore rent is optional. Then we move into criminal court, where a man facing years in prison decides the best strategy is to argue with the judge about jury instructions he never filed. This video is about one thing: what happens when people confuse YouTube law with real law. And spoiler alert, reality always wins.
You have to prove without the reasonable doubt. So let the record show that the judge has not required the plaintiff to prove without a reasonable doubt that I am a legal person, and it's on the record, not assumed, not presumed, on the record. There's nothing that's on the record that states.
Ms. Battle, first of all, reasonable doubt is a standard in a criminal case, not a civil case. So I do not have to prove anything beyond a reasonable doubt.
Sarah, I need both of you to stop talking, please. Both of you, I'm sorry. I cannot figure out the date because I can't hear over the two of you.
I apologize. I didn't know that's what you were doing, Your Honor.
This matter will be scheduled for May 6th at 3 p.m. for a trial on any and all issues that may be before the court. Ms. Battle, if you have anything else that you need to say, you can unmute yourself by hitting *6 to do that.
Okay, I just find it ironic that I got muted when I was speaking on jurisdiction and how there was a lack thereof on the record. So I want that to be on the record. But I also wanted to, okay, that's fine. And I also wanted to be on the record that I am not going to be able to show up on May the 6th. So it's also ironic that you are able to verify with him that he's able to show up, but not with myself.
I just asked you that, and you are now talking about something else. Why can't you do this?
That's because you cut me off and put me inside of a break room and muted my mic instead of allowing me to speak on what needs to be spoken on.
All right, this is set for May 6th at 3.
Your Honor, by Zoom? By Zoom?
Correct.
All right. Thank you, Your Honor.
It's ridiculous. This is a fraud.
This is sovereign citizen theater at its finest. Special appearance, consent to jurisdiction, facts for the record, it all sounds official, but none of it changes what matters. This is an eviction case. Civil court. Local jurisdiction. Lease agreement. End of story. The judge immediately lays out the basics. The court has jurisdiction because the property is there, the contract is there, and the dispute is there. That's how jurisdiction works. You don't opt out of it like a subscription service. What sovereign citizens hate most is simplicity. Because the simpler the legal framework, the harder it is to hide behind word salad. And this judge is not buying any of it.
Conference today was the motion deadline for both motions and motion in limines to be heard. Jury instructions were to be provided to the court by April 2nd, along with any proposed voir dire questions. We are set for trial on April 22nd of 2025. Mr. Raymer, you are charged with police officer resisting and obstructing causing injury, which carries a maximum penalty of up to 4 years in prison. Police officer assaulting, resisting, and obstructing, that carries up to 2 years in prison. There's 2 of those. And then there's a disorderly. And what is the plea offer in this file?
Your Honor, the people have offered to a plea of 2 counts to attempted R&O.
All right.
So 2 misdemeanors, and we would kill a brute to no upfront jail.
All right. Mr. Raymer, the plea offer in this case was to plead to 2 one-year misdemeanors with no upfront jail. And there'd be like 12 months or so of probation, some minimal fines and costs. Do you understand that? All right. Now, Mr. Raymer, you know, I'm assuming you graduated from high school, right?
8th grade.
You went through 8th grade, and this is a felony that could result in you going to prison. Why don't you stand in front of that podium for me? So do you understand an attorney can help guide you through the legal process?
Yes, I tried to have, I almost had a public defender. Unfortunately, she wasn't representing me appropriately. I'd asked for another one, but.
So I have no authority over who gets appointed. You're appointed an attorney.
I understand that, but when they're not representing you appropriately.
Okay, I didn't ask that. I'm just saying you have a right to an attorney. I know the attorney you're referring to. She's diligent. She works hard. Maybe you didn't like, I know when I was a public defender, sometimes my clients didn't like what listen to me, I'm talking. My clients didn't like the things that I told them. But, you know, her job isn't to do what you want. Her job is to represent the law. So you understand at this point, you can hire an attorney, or you can go with the public defender and whoever they assign you, or you can go to trial pro per with no law.
This is a huge misconception that gets people evicted all the time. You do not get to unilaterally rescind a lease because you decided it's invalid. Contracts don't disappear because you say, common law. That's not how any of this works. Lease ends when both parties agree, the term expires, or a court says it does. That's it. Sovereign citizens love pretending contracts are magical curses they can break with the right incantation. But courts operate on enforceable agreements, not vibes, and notice the judge's tone shift here. She's patient, but she's also warning her. Keep talking over the court, and this becomes contempt instead of confusion.
Provided against me. I have a right to defend myself using that very same.
That wasn't the question I asked you.
That's
You do have
exactly-
a right to defend yourself, Mr. Raymer. I'm just.
My
simply-
right for violence.
I'm talking, you're not. If you don't stop talking and listen to me so I can go through my speech, I will send you over to the jail. Do you understand? All right. You have not filed any motions. Jury instructions were due and voir dire questions were due. You have not provided those. We gave you a copy of this. So do you understand what I've received is what will be used? Yes or no?
I will be allowed to ask my questions.
What question?
When I'm cross-examining, I will get my.
I'm talking about juror question. I'm talking about jury instructions and voir dire questions. You understand now? You
I don't
didn't
have-
file, listen, I know, but you waived that because you have not provided them. Do you understand that? Do you understand that?
No, I don't. I don't
Okay.
understand that. I didn't understand that.
Okay, well, I
That's why
can't
I'm-
advise you of the law because I'm not an attorney, I'm a judge.
No, but you,
So-
you're looking at the case and you've been presiding over my case for 3 years now.
I know, it's fine.
You're the
You're
one-
gonna go to
You're the one
trial.
that signed the warrant for my arrest while I was in jail.
I don't know that, I don't
Yes,
remember.
you did do that.
Okay, I'm allowed to do that.
No, you violated my rights. of privacy.
Okay, well, you have options. You can file a complaint with the JTC if you'd like. So are you prepared to go to trial?
Absolutely.
Have you provided your witness list?
I haven't yet, but I will.
Okay, that was due.
My witness list was provided when, Ms. Underwood was my attorney,
Okay,
and my witness list is.
have you subpoenaed any witnesses that were not on the prosecutor's raised just eyewitness list?
Yes, my witnesses are the ones that was there at the scene.
No,
And
do
yes,
you understand that you have to provide a witness list and you have to provide a copy to the prosecutor? Do you understand that?
prosecutor, I gotta provide what to him?
So if you're gonna have witnesses at trial, you need to make sure the prosecutor has their name and contact information.
Ah yes, the classic move. I am not a legal person. Which raises an obvious question, then who signed the lease? Who lives there? Who showed up to court? Here's the thing sovereign citizens refuse to accept: if you can enter contracts, live in housing, and assert rights, you are a legal person. You don't get all the benefits of personhood without the responsibilities. That's not oppression, that's logic. The judge absolutely nails this by refusing to play along. She doesn't argue philosophy. She sticks to procedure. Because pretending not to exist legally is not a defense, it's just a faster route to losing your case.
Okay, I will provide the information. I
Okay.
will provide that information. Yeah.
I'm just telling you. So you need to make sure that there's a witness list in the file that was provided to the people.
So I gotta re-provide it.
I don't know. Go back and look at what
I'll
witness
just-
list
I'll
has
just
been
do that
filed, their name, their contact information. And then any subpoenas you have to do, if you have to subpoena anybody to be present, you need to get those filed this week. And then the court signs them and then you serve those people with those.
Yeah.
Do you understand? Now, do you understand when we go to trial, a lot of times some of the questions you ask or he asks may be objected to, and it's not personal, it's just, we have to follow the law.
Yeah.
Okay,
I'm allowed to object to though, right?
huh?
I'm allowed to object to.
You are, and then you have to provide the basis for that objection. Okay, so you need to understand your objections. So you might want to do some research to understand.
I've been doing.
Good, good. You sure you don't want a public defender for trial?
Huh?
You sure you don't want an attorney for trial?
This is one of the most ironic sovereign citizen moments you'll ever see. She claims fraud upon the court, while interrupting, talking over the judge, and refusing to follow basic courtroom procedure. Being muted isn't censorship, it's case management. Judges are allowed to control their courtrooms. Especially on Zoom. Especially when someone refuses to stay on topic. And notice the real issue here, she's not upset about eviction dates. She's upset that her script didn't work. Sovereign citizens often confuse being unheard with being wrong.
I am Brian. My family name is Wilkinson.
All right. We'll go on the record in State of Kansas versus Brian J. Wilkinson. Case number 25 CR 67. The state appears by County Attorney Darren DeVinny. Mr. Wilkinson appears in person by Zoom. We're here for a first appearance. Mr. Wilkinson, you're appearing by a summons. I'm going to go over your charges with you. There are 3 counts, all alleged to have occurred on June 4th, 2024 in Butler County, Kansas. Count 1 alleges you were in unlawful possession of methamphetamine. That is a level 5 drug felony. Count 2 alleges you are in unlawful possession of paraphernalia for use. That is a class B non-person misdemeanor. Count 3 is an allegation of possession of marijuana, also a class B non-person misdemeanor. Do you understand what you've been charged with, Mr. Wilkinson?
I do not understand, Your Honor.
Yeah, what don't you understand?
I had thought that this matter was already settled on the case that Mr. Watts was representing me for.
Okay, I'm not aware of that particular matter. That may have been a different case. I'm not sure.
Well, there wasn't a different case. I mean, I wasn't.
This is where the tone of the video changes completely. We're no longer talking about rent, we're talking about prison. Multiple felony charges. Years of exposure. And a plea deal that is honestly generous given the allegations. The judge explains it carefully. Plain language. No tricks. 2 misdemeanors instead of multiple felonies. No upfront jail. This is the system offering an off-ramp. This is where sovereign adjacent thinking becomes genuinely dangerous. Because stubbornness here doesn't just